Hello. This presentation is going to be in two parts as it seeks to explore on the two research questions as presented on the research poster on the screen. The first part shall be a critical examination of the duties and immunities of carriers as provided in the three set of rules: the Hague-Visby rules, the Hamburg rules, and the Rotterdam rules. Assessing the scope of application of these three will give us the necessary differences and similarities of the three different rules. The second part of this video will be an analysis and discussion of whether the implementation of the Rotterdam Convention will result in a legal uniformity and create a favorable environment for the shipping industry. The first duty, as presented by the Hague-Visby Rules, Article 3, Rule 1, is that of seaworthiness. The provision stipulates that the carrier is under the obligation before and at the beginning of the voyage to exercise due diligence. This is further supported in the court case of Maxine Footwear versus Canadian government. In this case, it was decided that the carrier had failed to exercise due diligence and had breached his end of the contract as the cargo had been ravaged by a fire in the attempt of the carrier and his agents to thaw some pipelines of the voyage. In contrast, however, the Hamburg rules does not have the seaworthiness provision for carriers. It does not have that duty. In terms of Article 5, Rule 1 of the Hamburg rules, the carrier is liable unless he proves that he and his servants or agents took all measures that could be reasonably necessary required to avoid the occurrence or consequences of loss. It's also important to note that the Rotterdam rules have preserved and adopted the seaworthiness provisions, and even so with an extension. It's been provided that there is in fact no reason why, once the ship has sailed from a port, the owner should be relieved from and duty to ensure its worthiness. Under the Rotterdam Convention, the carrier's responsibility with respect to seaworthiness is now not only before and at the beginning, but shall continue throughout the voyage. The second duty of the carrier is that of cargo management. Article 3, Rule 2 of the Hague-Visby Rules provides that the carrier has a duty to properly and carefully load, handle, store, and carry goods to the point of discharge. This position was confirmed and concretized in Volcafe Limited versus Companion case. In this case, some containers of coffee had been destroyed, and it was decided that the duty of care and cargo management is non-delegable, as it was the duty of the master or the carrier to ensure that everything had been in order. This same provision in the Rotterdam rules comes with an extra latitude, whereas the shipper and the carrier can decide or agree on who will be responsible for the unloading, for the carrying of the goods. The next duty is that of documentary responsibility. The carrier has a duty to issue a bill of lading in terms of Article 3, Rule 3 of the Hamburg-Visby Rules. This same requirement is also found in the Hamburg Rules, but in the Hamburg Rules, the provision is also made for the case where the carrier issues a document other than a bill of lading without any indication. However, as to when the carrier may do so and as to the nature of such a document. In the Rotterdam Rules, various alternatives are set out in Article 35. The carrier is bound to issue at the shipper's option a negotiable or non-negotiable transport document unless it is custom, usage, or practice of the trade not to use one. Already we can see that the Rotterdam Rules are moving with the times as they are modernizing and digitizing the processes. Another duty is the duty to pursue contract voyage. Article 4, Rule 4 of the Hague-Visby Rules provides that any reasonable deviation shall not be deemed to be an infringement. However, the coming in of the new Rotterdam Rules, a deviation shall come with penalties. In regards to the immunities, it's good to note that the immunities in the Hague-Visby Rules and those that are provided in the Rotterdam Rules, they are similar, except for the parts whereas the Rotterdam Rules has extended to cases of civil wars and terrorism acts. Some of the immunities provided in the Hague-Visby Rules are that of unseaworthiness, whereas the carrier is exonerated from liability in respect of loss or damage to goods arising or resulting from seaworthiness unless caused by the breach of the carrier of his due diligence duties. Some of the immunities both in the Hague-Visby and the Rotterdam Rules are the acts of God, perils of the sea, accidents of the sea, riots, restrictions, interference. In terms of the Hamburg Rules, the immunity is provided for the carrier. The carrier is not liable for loss or damage or delay in delivery caused by fire unless the claimant proves that the fire was a consequence of the carrier's negligence. In the case of live animals, the carrier is not liable if he can show that he complied with instructions given by the shipper. The ratification and adoption of the Rotterdam Rules is likely to achieve the legal uniformity of the shipping industry. This is proven by the multimodal regime that is being introduced by the Rotterdam Rules, whereas the whole shipping contract, is going to be bound by the same documents from the voyage by sea to inland or by air voyages. Other aspects to consider in terms of assessing if the Rotterdam Rules will be favorable for the improvement of the maritime contracts are the nautical effect, Article 4.2a, whereas carriers can now be held liable for negligent acts and for their faults that they used to be exempted from in the Hague-Visby Rules. The other point to consider is Article 8, Chapter 3 of the Rotterdam Rules that protects electronic transport records and also promotes the use of electronic documents. So far, the least favorable adjustment is that of the increased liabilities on shippers, whereas there are reduced liabilities on carriers. This is bound to cause so many problems, especially for the shippers, as they might find themselves being abused by carriers, as well as the freight forwarders who might find themselves wanting for subject to the abuse of this provision. Another thing to note is the extension in terms of the suit time, which is now 2 years, unlike the Hague-Visby Rules, which was one limited to 1 year.